The informational meeting will begin in 1 minute.
Good afternoon and welcome to it's Tuesday, October 3rd, to the City Council informational meeting. First item is UDC report.
Good afternoon, Jim David, Operations Manager for the City Council. I'll be very brief. The Urbanized Development Commission held their regular meeting on September 21st. A couple items of note include an approval of a letter in support of a federal grant for T. They are planning to reconstruct the road from the T exit to the T road, or it's called Heritage Parkway, to a 4-lane urban section. The UDC also approved the 2018-2021 Transportation Improvement Plan, or it's called TIP for the acronym. It includes all the transportation-related expenses, including transit, street, bus, any type of transit-related items. This is the document, and it is available on the Sioux Falls MPO.org website if you'd like to see a copy of it. And this is just an example of what you will see within that document, and it provides you with all the transportation projects over the next 4 years in the MPO. Happy answering your questions.
Are there any questions? Okay, moving to the next item is City Council open discussion. Councilor Starr.
Thank you, Madam Chair. Wanted to just update the council and the city and say thank you more than anything. In the last week or so, went to 2 neighborhood association groups that got a chance to meet. Councilor Staley was part of that, and I know Councilor Erickson, you did a nice job of helping the residents in Norton Acres with some of their zoning questions. But Matt Tobias and Jason Bieber showed up for the Norton Acres meeting. It was awesome. There was about 35 people that showed up in the park to get a chance to talk about their decision-making process, whether they're zoned appropriately. But we also had representatives from the fire department and the police department, because there's nothing like a fire truck and a couple of squad cars to gain some attention of the neighbors by the time we're done. So more than anything, it's exciting to see people in neighborhoods in Sioux Falls getting together and talking to each other before there's a problem and before there's an issue. So, and the other one I didn't say was the Oakview Neighborhood Association got together at Kenny Anderson Park on Saturday afternoon in between raindrops, and bouncy houses and food, and neighborhood kids came together and families and that area. So it was exciting to see members of the administration there that were also able to help with the police and fire. So it's good.
Thank you. Any other? Councilor Rolfing.
I'm the oldest one, not you.
I know, I almost forgot.
I just wanted to say something about the announcement that came out about our city attorney today. I've been around now for 7.5 years, about the same time as Dave has, and I've enjoyed working with him. It's been an honor and a privilege. We're losing a good man, but the state's picking up a good man. And so I just wanted to say personally, and I'm sure from everyone here, thank you for your service. Continue it, and I hope the next mayor or whoever picks one half as good as you are will be in good shape.
Thank you. Any other open discussion? Okay, we'll move on to the one and only presentation that we have, the Event Center Settlement Agreement. Before we start, I just wanted to say thank you to the administration for honoring the council's request to have you come before us today. The intent of the presentation is really to provide all of the council to ask any questions that they see fit in regards to the event center and the settlement that was recently opened. As the chair of the meeting, I want to make sure that all the council has the opportunity to ask any questions that you have. We do have until 6:30, and if needed, I intend to go that long should there be that many questions. If we need to hold over, we can certainly discuss another session if need be. I know a lot of the information that we just got was just received here some time ago, that if it does take some extra time, we will do that. So with that said, I want to make sure that we are respectful and that we have the opportunity to ask those questions. And the first presenter, I believe, is Mayor Mike Huther.
Council Vice Chair Erickson, thank you so much. Actually, you stole a little bit of my thunder, my introduction, but thank you very much, and councilors, thank you as well. This is a great opportunity to engage the council. We're really looking forward to it. We've attempted to answer not only the questions that have come from the council, but also from other entities within the city as well, including the media. There will be a number of us that will come up to try to address those questions, but we also realize that there's going to be other questions as well, and that's why we're here. So to kick us off, I'd like to introduce you to, as Councilor Rolfing had mentioned, City Attorney David Fifley. David?
Thank you, Mayor. Councilors, glad to be before you today. Dave Fifley with the City Attorney's Office. We're going to try and address, as the mayor indicated, the questions that have been coming both from you as well as media members and others, and we have several slides that we believe will be a composite of all that information. I'd ask Heather to switch to the first slide, please. The question we are often getting is who is at fault? Certainly, no party has admitted fault in this instance regarding the installation and aesthetic appearance of the metal panels. It is a standard provision in settlement agreements that no party admits fault. And so all the parties came together to resolve the issue, as we'll discuss as we go forward. Slide 2. Why did we have to hire an expert, and how much should we spend on legal fees? The city hired a national expert, attorney Jeff Applebaum, out of Cleveland, Ohio, who worked with all the parties to resolve this issue. Jeff is ranked as a top 10 lawyer in the country in construction law. He has acted as a mediator or facilitator in hundreds of large construction projects across the country. He came highly recommended, and he has been a mediator or facilitator on a wide variety of construction disputes across the country. Certainly his specialty includes stadiums and arena construction, where he is intimately knowledgeable of those types of issues. The City Council approved the use of his services, and the city paid him approximately $94,000 for his services. The city was also required to hire Steve Landon of a local law firm, Cadwell Law Firm here in Sioux Falls, to commence a suit to enforce a settlement agreement that we thought had been achieved at the mediation in May of 2015. Mr. Landon was going to serve as the litigation counsel because Karen Leonard and I were personally involved in the mediation process. Now, our rules of ethics require that attorneys who are involved in a factual issue or have factual knowledge can't testify as to facts and also act as an advocate. So that was a unique situation where we had to retain the services of outside counsel. Mr. Landon and I have had cases against each other or with each other both for many years. He's a highly experienced litigator. His fees totaled approximately $9,000. So the total up there of $103,577.38 is the sum total of those two attorneys' fees. Slide 3, will the public see the draft of the Judd Allen Group report? The city retained the Judd Allen Group to be a possible trial expert in anticipation of litigation. It is a common practice in anticipation of litigation that you seek out who might be an expert to use in that litigation, and you try and quickly bring them to the site, frankly, and have them view the site as quickly as possible so that they will be ready in case litigation ensues. The Judd Allen Group provided only a draft preliminary report indicating that much more research and review would be required for them to finalize any opinions. We spent approximately $4,891 on the Judd Allen Group preliminary draft report, and that included travel expenses from the Twin Cities as well as 2 days spent on site here, both interviewing people and also viewing the event center metal panels. As the report remained in draft and was ordered in anticipation of litigation, state law specifically provides that draft reports are not public documents. We will not be providing that draft report for public inspection because it was never completed. I'll now turn it over to Public Works Director Mark Cotter.
Thank you, David, and thank you, City Council, for the opportunity to come here today and talk to you about this agreement. I have 3 questions today that I'll take you through and provide you answers to. So, first question, why was the siding not replaced? The metal siding is performing very well. It's a functionally and structurally sound exterior siding system and doing what it was designed to do. The curve on the metal panels on the west wall was not as smooth as we expected. However, ultimately, in collaboration with our design and construction team, we came back to it is functionally and structurally doing what it was designed to do for the building system. All right, next one. All right, if we were to replace the siding today, what are the risks? And there is no guarantee that new siding would look any different than it would, and we would not recommend to replace a functionally and structurally sound system, okay? And a question that's come up a number of times is, what warranty does the system have? The siding initially had a 3-year warranty for the wall panel installation. The substantial completion of the building was August 1 of 2014, and so that 3-year installation warranty has since expired as of August 1 of 2017. It does, however, have a 20-year finish warranty. The finish essentially protects the metal panel, and that is essentially the key warranty for the system. Thank you for the opportunity to speak to this agreement today, and now Director Tracy Turback will speak to you on a number of questions. Thank you.
Thank you, Mark. Tracy Turback with the Finance Office, and I will be addressing some of the financial elements related to the settlement agreement. First, I want to say that due to the very explicit confidentiality provisions of the settlement agreement, only the $1 million global amount of the settlement was permitted to be stated publicly. To disclose any detail other than just that $1 million amount would have constituted a breach of the agreement. So our hands were tied, and they've now been untied, and so we're here to talk about some of the specifics. The $1 million is comprised of the following amounts: cash of $443,719, and I'll detail that on the next slide. $41,285 is for forgiveness of debt, or what I will refer to as a payment avoided. That is for architectural fees incurred on the project that had not been paid yet by the city. The balance of $514,996 was a transfer in contingency dollars contained within Mortenson's contract back to the city, which in turn resulted in a reduction of the guaranteed maximum price set forth in Mortenson's contract. Now, given the alternatives that we faced when this dispute arose, this forfeited contingency also became a payment avoided by the city by entering into the settlement agreement. Now, some will say that this amount of money, that this money would have been coming back to the city anyway. That is simply not true. If we had continued to fight and told Mortenson to fix the problem, Mortenson could have used their entire contingency, not just this $500,000, to attempt to fix, with no guarantee that the siding would look any better. I absolutely believe the $514,000 $996 did benefit the taxpayers. There is no doubt in my mind. Who paid the cash? The $443,719 in cash was received from a Metco, who paid, that's an Innovative Metals Company, the supplier of the metal panels, $40,000. Sink Combs Deathless and Coke Hazard paid $118,719. The insurer for MJ Dawson contributed $125,000, and Mortensen paid $160,000. So those four different parties contributed a total of $443,719. One point of confusion, I think, that was initially reported on was why did the city release money under the agreement? And there are really two parts to the answer to that question. The first relates to the Premier Center project. When the siding dispute did arise, the city withheld a portion of the city's payment to Mortensen. And that was for work that had been performed on the project. So they had billed the city for work performed on the project, and the city withheld payment. Because the dispute also involved Dawson, who was a subcontractor to Mortensen, Mortensen then in turn withheld payment to Dawson. Once the dispute was settled, pursuant to the settlement agreement, the previously withheld payment to Mortensen was released by the city in the amount of $440,445. And in turn then, the previously withheld payment from Mortensen to Dawson was released by Mortensen. This all involved work that had been completed under contracts entered into prior to the settlement agreement. The city paid out no new money pursuant to the settlement agreement beyond those previously existing contracts. In fact, the settlement agreement clearly states that this payment was made in full payment for the contract balance owed for work performed on the project. The second part of the answer to that question relates to the convention center. Separate and apart from the event center project, but occurring at the time the event center project was ongoing, the city had entered into a contract with MJ Dawson directly for improvements to the convention center. When a dispute arose on the convention center project, the city withheld a portion of the city's payment to Dawson for their work performed on that project. When this dispute was also settled under this settlement agreement, the previously withheld payment to Dawson was then released by the city in the amount of $54,555. Again, this all involved work that had been completed under a contract entered into prior to the settlement agreement. Again, the city paid out no new money pursuant to the settlement agreement beyond the obligations of that pre-existing contract. Again, on this particular point, the settlement agreement is very clear that that payment was full payment for the contract balance owed for work performed on the project. So back to the cash. Where did the cash received by the city go? The $443,719 in cash received under the agreement was placed in the Event Center Construction Fund. Now, following the election back in November of 2011, where the voters approved this project, an Event Center Construction Fund was created on the city's books and within the city's budget. All funds received by the city for the Event Center project were deposited into this fund, this Event Center Construction Fund. That includes bond proceeds, interest earnings, contributions to the project by outside parties, the $443,719 in cash received under this settlement agreement, and any other funds received by the city as part of the project. All of that money went into the Event Center Construction Fund. All dollars in this fund are considered fungible Event Center project funds and can only be used for the Event Center project. Now, this fund currently has a cash balance of approximately $2.9 million. And clearly, a large portion of that relates to the fact that the project was completed well under budget. So how will the money be used? Or how has it been used? Since opening the Event Center in the fall of 2014, and since the settlement funds were deposited into the Event Center Construction Fund in the fall of 2015, many expenditures have been made from the Event Center Construction Fund on improvements to the Event Center. Some of those projects have been completed, some are in progress, and others are upcoming. Some of the projects that are completed include improvements to the security system for the building in the amount of $139,627. We purchased metal detectors for the building in the amount of $122,250. Additional radio equipment was purchased for $48,035. A new score table and video equipment was acquired for the building at a cost of $40,736. Additional concession equipment for $32,045 was acquired. Additional trash receptacles in the amount of $28,282. Portable beverage stations, we purchased some additional beverage carts for $23,298. And cell phone charging stations were installed in the facility at a cost of $19,937. Now, these are all relatively small items. The larger projects are projects that are either in progress or upcoming. Those include the, and I should mention that these, because they are either in progress or upcoming, the dollar amounts are estimated costs since they have not been completed, and final costs won't be known until they are completed. The cooler storage and kitchen expansion project, $1,397,097. That project is nearly completed. In fact, the cooler became operational just shortly before the run of the 9 Garth Brooks sold-out shows. The parking lot lighting, $320,356. That bid, the bid for that project has been awarded, and work will be completed on that LED parking lot lighting over the next several months. Additional seating, $110,700. Bids have been received on that project and are scheduled to be awarded this month. And last, an upcoming project that has not yet been designed that we do plan to move forward with to complete next year is a caterer kitchen. The last thing I'll mention in regard to how the money will be used, that the 2018 city budget that the council just adopted last month provides for any unspent dollars remaining in the Event Center Construction Fund upon fund closeout to be transferred to the city sales tax fund, and those dollars will then be used for ensuing debt service payments on the next Event Center sales tax bond payment. With that, I will turn it over to Karen Leonard to address the next segment of questions. Thank you.
Good afternoon. I'm Karen Leonard. I'm Deputy City Attorney, and I'll be answering some of the questions regarding the settlement itself. The first question, if the siding were to be replaced, how much would that cost? In 2015 dollars, it was estimated that it would cost between $850,000 to $1 million to replace the panels on the west end of the Premier Center. Next question, why was the City Council not included in the negotiations? Some of you might recall back when you approved the construction manager at risk contract, the City Council did approve the contract, and within the contract it set forth a dispute resolution process. We did follow the dispute resolution process set forth in the A-133 and the general condition document that was approved by the City Council. Negotiating contracts and agreeing to settlements is an administrative function according to state law. What was the actual amount of the construction manager's contingency remaining at the end of the project before and after the settlement? A final reconciliation of the project construction costs established as follows. At the very end of the project, the construction manager contingency fund was in the amount of $1,524,402. As a result of the settlement agreement, Mortensen Construction forfeited $514,900 $996. What's remaining is $1,009,406. Did the city of Sioux Falls count money that already belonged to the taxpayer as part of the $1 million amount? The construction manager contingency is separate from the owner contingency. The construction manager contingency fund existed to protect the construction manager against the risk assumed when providing a guaranteed maximum price. This was a line item in the guaranteed maximum price. The construction manager contingency fund does not become the owner's money unless the construction manager relinquishes its rights to the fund and the final guaranteed maximum price is reduced by the amount of contingency returned to the owner. So it was not, it was their money until they relinquished that money in the settlement agreement. Even if contingency dollars are returned to the owner as part of the final payment process, the construction manager still has the right to recapture those dollars unless that right is released. Section 13.7 of the general conditions allow commencement of certain claims to occur, for example, latent defects within 10 years of substantial completion, which is August 1st, 2024. The construction manager has waived all rights to use the forfeited contingency dollars towards fixing latent defects, as normally the owner is required to reimburse the construction manager for dollars expended up to the full amount of the final GMP, including the unspent construction manager contingency. The forfeiture now places the construction manager at additional risk, as it has no recourse to those dollars. If the city had demanded replacement of the metal panels, the construction manager would have been allowed to use contingency money to do the work. And I want to repeat that. If the city had demanded replacement of the metal panels, the construction manager would have been allowed to use contingency money to do the work. Even though the panels weren't replaced, the construction manager forever gave up its right to the forfeited dollars for other issues which may arise between now and 2024, and they also reduced the final GMP. At this time, I'll turn the presentation over to Mayor Mike Huther.
Thank you, Karen. I appreciate that. Some additional questions that have come up more than once over the last couple of weeks. And I felt it was appropriate that this mayor answer these questions on behalf of not only the city, but certainly in front of the city council. Why did the city of Sioux Falls agree to the settlement? Well, the alternative would have required a long, drawn-out, and yes, certainly expensive litigation process to try to prove liability among several contractors and design professionals. The city could have spent hundreds and hundreds and hundreds and hundreds of thousands of dollars in fees and other litigations costs without any guarantee of outcome. In life, in business, and yes, even in government, litigation is normally the last and certainly the least preferred resort. You're always balancing the risk and reward when it comes to litigation. Finding common ground amongst the parties, that's always the preferred option. Council, and yes, people of Sioux Falls, one thing that many of you may not realize is that oftentimes, after considerable time, effort, resources, and money that's expended in litigation, the judge oftentimes will tell you, I've heard both sides. Now, I need you to go into that room and I need you to settle it. Settlements allow partners to move on and to do more productive things with the time, their talent, and indeed the treasure. And that includes City of Sioux Falls treasure too. So Mayor, why was the settlement agreement confidential? Again, council, people of Sioux Falls, there are times during settlement negotiations, no matter how hard you try in this settlement, when the settlement can only be achieved through a confidentiality provision. Council, if I can just ask for your attention just right now, please. The city did not ask for it. The other parties did. I'm going to repeat that. The city did not ask for it. The other parties did. However, once the agreement was made, and then, yes, signed, the City of Sioux Falls lived up to those terms. And to be clear, we will continue to live up to the terms of the agreement as best we can. However, once the Supreme Court reversed the lower court's decision, we respected it. And the City of Sioux Falls released it to the public. And we did it the very next day. We didn't have to, but we did. We released it the very next day. Mayor, why did the City of Sioux Falls tell the citizens way back when that it was $1 million settlement? Because it was. The amount consisted of cash, forgiveness of debt, and a transfer back to the city of contingency dollars contained within the Mortensen contract. I hope that the folks in the audience, and I hope that the council truly were able to understand what Karen and Tracy so eloquently tried to relay to you, because I think they did a really excellent job. And you know what they did? They actually focused on the facts. They did. And I thought they did a really thorough job in explaining it. Now, it's not easy to understand, but it was factual. They weren't trying to be misleading. They weren't trying to certainly be inaccurate. They tried to explain it to you as best that they could. But here's the reality, is that for some, no matter what answer is provided, it's not the answer they want to hear. That will always be a reality. In any case, the value of the settlement to the citizens, it was real. And citizens of Sioux Falls, it was considerable back then. And the city has and certainly will benefit from it, from that value, from that settlement. Here's another important part to remember. And this is so real that the amounts that were provided by the partners back then to the City of Sioux Falls, it didn't come without a bunch of care on their part, a bunch of concern on their part, and yes, a bunch of vetting by their organizations, including certainly their legal team. Now, I'd love to take us back, if you don't mind, 3 years ago. Because again, 3 years seems like a long time, but I do need to take you back. City of Sioux Falls, we really had 3 options back then. We did. Number 1, do nothing. Do nothing. And you know what, Sioux Falls? That's what happens a lot of time in government. Happens in federal government all the time. Happens in state government. and it happens in government all the time. Just do nothing. What we try to do is, no, we told the folks back then, no, we believed that there was more to this, that we did want to fight for the taxpayers. We did want to fight for the citizens, and we did. We did. And our goal back then was to reach a settlement. Or number three, and certainly it was an option, and we thought about it. We did. We thought we could go through a long, certainly protracted legal battle. But here was the reality. Even if we prevailed and then replaced the siding, there was no guarantee of improvement anyway. The city of Sioux Falls negotiated, and you bet, we agreed to a settlement. It was in the best interest of the taxpayers back then, it was in the best interest of the citizens back then, and it was in the best interest of the city of Sioux Falls back then to settle this case. The reality is this, is that when you're going to have disagreements and disputes in your homes, in your businesses, small or large, in your churches, in your nonprofits, and yes, in government, this process to try to resolve these disputes, they're always a battle. They're never easy. And then what you find out is that even after they're settled or after they're negotiated or even after the solution is attained, it's never going to satisfy the two sides. However, you do the best you can. And that is exactly what the city of Sioux Falls did back then, and that's exactly what we're going to continue to do in the future. At least I hope so. At least I hope so. I hope that future leaders don't use option number one and do nothing. I was incredibly proud of the city of Sioux Falls team during the negotiations. And I'm going to stand before you here today and tell you I am even prouder of them today. Even prouder of them today. It is an honor to serve with these people. And let me just stop there. Here's, again, another reality. The Event Center project was an unbelievably successful construction project. It was on time. It was under budget. It created thousands of jobs. It is being operated, our event center is being operated in an incredibly successful way. We actually have a publicly owned, publicly run center that is operating in the black, substantially in the black. It has generated millions of dollars in economic development, and we just celebrated our 2 millionth visitor. And council, I'm going to leave you with this. It is beautiful inside, and it is beautiful on the outside too. If you don't agree with any of that stuff, I hope that you can all agree that we have and will continue to reap the rewards and the benefits of our events center. Council, we truly do appreciate this opportunity to engage you. If I could do anything different, here's one thing that I would do different. I would have had this meeting a week ago. But we're here before you today, and so we are looking forward to your questions. We're all here. And so please, Council, we're going to leave it in your very capable hands. Thanks for the opportunity, Council Vice Chair.
Thank you. Thank you. I'll turn this over to councilors with questions. Councilor Selberg.
Thank you, Madam Chair.
Thank you, Mr. Mayor, and your team for being here today. I think it's nice that we're finally getting together, kind of clearing the air today. I've got a couple questions. I think a couple of you have touched on them a little bit, looking for something maybe just a little more specific. I mean, we've been told time and again that we've gotten a heck of a deal on this settlement, and I think to say that it would seem that we'd need a pretty accurate number as far as what it would have cost or what it would cost or will cost to repair the panels. Do we have an idea, kind of a more specific number, if we had to replace them or decided to replace them today, what it would cost?
I think that's certainly a fair question, Counselor. You know, when we looked at the full scope, when the entire envelope system was bid, not only the flush metal panel but the corrugated, that metal siding, along with the girts and the tieback system, was about $1.76 million. And so then when we bring it down to just that west side that Karen had mentioned, back in 2015 being, $850 to $1 million, I would expect that, you could utilize some kind of a range of 3 to 6% of inflation to modify those numbers up. That would be a good starting point from a budget standpoint.
Okay. Okay, that works. Kind of the similar type question. We've been told, like, with this settlement, it was a win-win because we didn't have to worry about additional court costs or paying lawyers, that type of thing, too. Do we have a more specific number, what we think that probably saved? Kind of an idea?
Counselor, based on the types of issues that were involved here, there were several. In terms of, you had issues regarding installation, manufacture, design. So you're looking at 3 potential areas for experts. And I litigated cases for 16 years on behalf of several government entities across the state. I did some construction litigation in my practice of 16 years, and I can tell you, you don't get an expert on one issue for less than $100,000. That is simply unheard of. So you have it, in this instance, you have at least 3 different issues. You probably need 3 different expert opinions on to go to trial with. So you're looking at about $300,000 in expert fees on that. In terms of depositions and so forth, you can imagine it's called a discovery process before a case actually goes to trial. In that instance, every time you take a deposition, it could be $1,000 for a transcript. You have a lot of people working on a project here. You have 300 or 400 people on site on the event center at any given day during its construction phase. You have tons of design professionals, other professionals working on it that aren't even on site. You had a potential witness list of 500 to 700 people. I'm just guessing. If you take that in terms of the number of depositions you need to take, it would easily be $50,000 to $100,000 in terms of getting to the places where they are located, travel time, paying for a deposition transcript each time. So to answer your question, I mean, a ballpark figure would be $300,000 to $400,000. So when the mayor used the word hundreds, I believe I counted 4 times. That was accurate.
Okay, thank you. I can understand why some negotiations on occasion may need to be confidential in an effort to come to an agreement. The only thing, it just kind of appears with this, the more we seem to learn, the best way I can put it, it's been a little confusing and it's been a little bit sloppy, I guess is maybe the way I'd put it. You touched on this, Mr. Mayor. I mean, in retrospect, is there anything that sticks out other than maybe meeting with us a week ago or a week earlier that maybe you could have or should have done a little bit differently in how this has been handled?
And Councilor Silberg, you did direct that to me. And so I'll try to answer it from my perspective, but also I think that Karen or David, you're the legal minds of the city of Sioux Falls. I think you should try to do it too. Sincerely, the one thing that I would change would be I would have preferred to address this in a more aggressive fashion. I call it an offensive strategy. I would have done that easily a week ago, if not earlier. Because oftentimes what I've learned over the 7.5 years that I've had the honor to serve you is that if you allow people to speculate, if you allow people to come up with their own answers, if you allow misleading comments or inaccurate comments to ultimately drive the day, or worse yet, drive the dialogue, you do find that it doesn't serve anybody well. And so that is the one thing that I personally would change, and I've recommended that to the city team in terms of when I'm done being the mayor, because I think getting out in front of it is better. But as for the settlement itself and the process, I strongly believe it was one of the biggest wins that we were able to accomplish. It was big, because again, as David, he wasn't able to go into too much. There was so much involved in this, and so when you look at the risk reward of litigation, this is one where I was so enthused about it after I was told what ultimately was agreed to. I was just thrilled by it, because number one, we could move on, celebrate our new event center. We were able to generate $1 million in value for the taxpayers, for the citizens, that we can use in a much more constructive ways than taking down a facade and then putting back a facade and hoping that it would work. And so no, as for the settlement itself, the team in terms of what they were able to accomplish, I appreciate that. But Councilor Selberg, one thing also I've learned, you use the word sloppy, and I think that's appropriate. Government is not as clean as you will find in business. It is sloppy, and that's okay. I've learned that over the years, that there are various parties, including the legislative branch, the judicial branch, the executive branch, the citizens, the media, and that's what makes it tougher. However, council, remember I did say something, and that is we didn't want this to be confidential. But in order to settle it, in order for us to move forward with and receive this value, that was insisted upon by the parties. Okay. Now, I don't know if the team mentioned this, but I'll mention it now. One thing, though, that we insisted on, okay, and David, maybe you and Karen can explain this better. Here's one thing that we insisted on, because again, some of you weren't on the council back then. One thing that we insisted on is we wanted to relay at least the value of the settlement. We did, and through that negotiation, we were able to at least release that to the public in hopes that we could at least give them some understanding that it was a good deal, that we did receive a value, that the taxpayers, that the citizens ultimately won. And so they conceded on that point. Is that fair, David and Karen? Thank you. So, sorry, Councilor Selberg, that may have been a long, drawn-out answer, but again, to simplify it, you bet, I was unbelievably pleased with what transpired 2 years ago. And again, I still am very, very pleased with this today. Now, you didn't say 3-4 years ago, certainly. One thing that you'll also learn, whether you're building a house, whether you're building a church, whether you're adding on to your business, or yes, building an event center, that construction projects are not perfect. And certainly this one wasn't, even though it was under budget substantially. It was on time, did create a bunch of jobs, and it's unbelievably productive today. Sorry, Councilor. Thank you.
Thank you.
David, any thoughts on that?
Thank you. Sure.
Just to amplify what was indicated by the mayor and councilor, in terms of, as a government entity, probably one of the best cards we have to play at a negotiation is the fact that we don't have the risk to our business reputation that private entities have. And most of the time, they want a confidentiality provision on the other side, and that is to preserve their business reputations. And certainly, you can assume that that was the type of element that was running through this particular instance. And the mayor is correct. We demanded that we be allowed to state the total amount involved so that we could inform the citizens and the taxpayers. So it was certainly one of those situations where you either accept the partial confidentiality in terms of the specific amount of contributions from each of the parties, or to be kept as confidential, or you risk losing the entire settlement. And based on the fact that we probably were at risk no matter what the outcome was, whether we succeeded or not in litigation, you would have spent about $400,000 just on expert fees and deposition fees and so forth, just to try and get to the answer. It certainly was a wise decision financially and legally. So,
Okay. Thank you.
Thank you. Councilor Staley.
Well, first of all, I want to say that I'm so grateful that we have citizens who came out for this today, and I'm hoping that people are watching this as well, because this is very important for our community. The citizens in our city of Sioux Falls deserve to know the truth, and I believe that people can handle the truth. They can handle the details. And I believe that the public trust has been violated. I've been out talking with people. They're very concerned. And I think the people deserve to know what's going on in our city government and what we're spending our money on, our tax dollars on, and the projects and the contracts. In my time on the council, and I've discovered there's a secret society happening in our government. We've had things kept from us constantly, whether it's the issue of the investors involved with that downtown multi-use parking ramp that's going to cost the taxpayers supposedly $17 million, whether it's a secret executive session calling us in to tell us that we cannot advocate to help citizens as council members, the issue of these RFPs, that we get a few bureaucrats in the room with some city council members making decisions about contracts that we don't know all the details of, the public doesn't know, and then we're given a winner and we get to sign off on the dotted line. And just recently also we have a city audit company, or a company that's been auditing our city since 2011. Some of us advocated having that rotating so that we have another set of eyes looking at the situation, and it was knocked down, barely even brought before the public on that. So I'm just saying, this is, to me, it's symptomatic of a bigger problem that we have going on within our city government. Now, we were told that this could cost hundreds and hundreds of thousands of dollars had we taken this to court to force these people doing the work on our event center to be accountable for what they're doing and to stand behind their work. And I wanted to point out to the public that back in March, we had the Parks Department bring before us wanting to have a new snowcat groomer for $300,000 for Great Bear. We have one that works. I said, why can't we wait on this, especially now with the downturn in the sales tax economy? We were told, oh, we can't do that. It will harm our children if we don't have this brand new snowcat groomer. So we have money. We're watching this happen all across the board within our city government. We're spending hundreds of thousands of dollars on different things. But when it comes to defending our right to have this done right within our event center, then all of a sudden we're trying to take the cheap way out. Now, I challenge you to go back to the July 22nd, 2014 meeting, and it's up on the YouTube channel of, I believe it's siouxfall.org, and you're going to see Attorney Fifley up there saying that these are non-conforming panels. So back then, and this was brought up because we have citizen Bruce Danielson saying that there's a problem with what's happening with the appearance of these event center panels. David Fifley said at that time that they were going to identify the problem, they were going to find a solution, and then they were going to fix the problem. And there were council members back on that July 22nd, 2014 meeting who said, let's not close on this deal until we find out more about what's going on. And they were told by other council members and by the administration, don't worry, we're going to take care of it, it's going to be fine. And then before we know it, we have the settlement happening. So to me, I'm looking at this and I'm saying we're looking at what was, what is, and what's to come. And at the end of the day, I mean, people have been saying, what do you really want out of this? I think that we need to have an audit. I think we need to have an independent auditor come in to determine what actually took place. And we are told that we can't see the report that was done, or we paid for it, but it's not there. I think moving forward, we need to take this out of the administration's hands, and the council needs to step up and say, we're going to do due diligence for our citizens and show you, first of all, what's really going on with those panels, and then do we want to make it right within our community? Do we want those to be the way they were supposed to be? But then we also need to break this open the windows, open the shades, open the doors, and let the citizens know what's really going on. I talked with a general contractor, and he said that in his opinion, in his experience, you always have a bond, or two bonds, one for labor and material, and a performance bond. So now this is going back to a question to maybe Mark Cotter, but I've been asking, why didn't we have a more stringent warranty that when this was brought up in that meeting in 2014, at that time, why didn't we go back to the people who did the work and say, make it right?
Director Cotter, do you want to come forward and answer Councilor Staley's question in regards to the warranty? I'm not sure, was there another question other than that one?
That's the question, yeah, that is.
Thank you. That's
Certainly, Council Chair and Councilors. So we do have a very good warranty, and it's to have actually a 3-year installation warranty that comes with the Ametco panels is a very good warranty, because we've been able to now observe through the extreme weathers of South Dakota how this system functions, and it's functioning very well. The next thing that we have a 20-year finish warranty. The finish system on this is what protects the metal so it can have a longevity. So I would contend to you that we have a very good warranty in addition to Mortensen Construction's performance and payment bond. So.
Did you have a follow-up in regards to the warranty?
Well, I guess I still, going back, at the end of the day, we've got the panels that are bulging. The mayor can say they look attractive and they're okay the way they are. A lot of people don't agree with that. So I don't think my question was answered as to why we didn't have them be accountable, and we entered into this settlement. That's, in my opinion. And the buck stops with the people doing the work.
Is there anyone else in the council that has additional questions? Go ahead, Councilor.
Yeah, let's dig into the construction manager's contingency. I think that's really important. Jim, could you bring up my Exhibit 3? I have some documents that I'm going to put on the screen just for the aid of everybody so we can kind of follow along, because this is just complicated. So in this one, this is the contract with Mortensen, and I'm going to the part with the arrow. I just want to get clarity on all savings if the cost of work plus a construction manager's fee is less than the final GMP shall be returned 100% to the owner. Can somebody clarify that this whole construction manager contingency, would we have gotten this money back anyway? Or I shouldn't even say back, retained, because if we don't authorize the contractor to use it, well then there's nothing to get back. It's our money.
Okay, yes, the contract does say in section 5.2.1 that the construction manager contingency fund, if there's any remaining dollars, do get returned to the owner. But there's also a section in the contract in the general conditions, and that is section 13.5 or 13.7 of the general conditions, that allows for additional claims to come forward. So even though we closed out the project And the construction manager did return the remaining contingency fund dollars to us. During the next 10-year period from the date of substantial completion, which is August 1st, 2024, they have permission to come back and recapture the dollars that they returned to us to pay for any latent defects that occurred. There is something in the law that's called the statute of repose, and that is a specific statute in state law, and it applies to construction contracts dealing with latent defects. And so we put in the general conditions that we understand that claims can't go on forever, but they have to end, and it's within that 10-year period of time. So what the construction manager did here, when they gave up the $514,000, they waived, forever released that money back to the city, so that now they can't recapture what they gave back as part of the settlement. And that was a big deal to the city, is that was real dollars that came back to us, because we now don't have to release what was agreed to in the settlement agreement back to them.
So if there's a problem with the panels or the roof going forward, can we go back at them and make them fix it?
On the panels itself, we have settled that, except for, in the settlement agreement says, it is expressly understood and agreed, and this is in section 5.3 of the settlement agreement, it does not release any of the parties from any contractual guarantee, warranties, including but not limited to the Golden Seal Total Roofing System warranty, or duty of indemnification or other obligations set forth in the agreement and subcontract identified above that may exist relating to any third-party claim for personal injuries, property damage, or wrongful death, which may have arisen or arise as a result of the work performed on the Premier Center project or the Sioux Falls Convention Center project, or for future claims that arise out of latent or hidden defects. So none of the parties agreed to waive any claims regarding any latent defects that could be discovered during that 10-year window.
Other than the panels?
That wasn't hidden. That was something that we already observed, and we brought that forth under the contract that was non-conforming. And to go back to answer the question, I think a little bit to you, Councilor Staley, is that all the parties came together in determining who's at fault, whether it was an installation issue, was there negligence, all of those remain questions that were very gray. This was not a black and white case. And it does, to you, Councilor Selberg, come back to you, that it was a complicated case. And the parties did come to an agreement that they would make contributions towards settlement, because there was risk and exposure to each one of those parties had we litigated it.
So again, for the panels, are all of the private parties released into perpetuity for liability on the panels?
For what we identified on the west side, if I don't use the right term, Mark, you can correct me, the oil canning that was occurring on those panels, that have been released.
So the construction manager who was supposed to be at risk is now released forever from liability for $160,000 on our panels?
$160,000?
Yeah. I mean, they paid $160,000. We were going to get the $500 back if there's no latent defects anyway, correct? I mean, this money we'll get back. It's our money, unless there's some other latent defect that comes up.
Whatever's left over at the 10-year period does come back to us, yes. And so I think, not to confuse the issue, at project closeout, they return the money, but they have a right to recapture the dollars that they did not release in the settlement agreement, should there be any latent defects or other reasons in that state law. That was one example.
Have we had any latent defects so far?
Not to our knowledge, no.
But
10 years is a long time. Normal statute of limitation is 6 years for a breach of contract, and so there's a reason why our legislature knew in construction cases that under the statute of repose, they would make it longer during the 10-year period of time.
Okay, well, not to belabor the issue, but that contingency is our money, so if there's no defects that they have to fix, I don't see how that's particularly a windfall. So I guess I would just go back to, I think Mortensen, who is on the hook for this, was released from liability for the panels that we've said would cost $1 million, probably more to fix, for $160,000.
I can't agree with that final statement, Councilor Knight.
Okay.
Thank you.
there any additional questions? Otherwise, usually chair goes last. I can go if anybody, go ahead, Councilor Starr.
Please, thank you, Madam Chair. I guess, Attorney Fifley, if you don't mind, can you take us through the $1 million? What was actually, as part of the settlement agreement, what was settled? You know, give us because that's what constituents ask all the time. What did we settle? Did we settle a problem with the siding? Did we settle a problem with the roofing? What did we settle as part of the agreement? Because it does, in the parts that I've had a chance to study a little bit, it talks about there's also a roofing problem that we settled as part of this settlement, or is it?
Certainly. There's a couple components here, and again, when you have a global settlement agreement, Counselor, you try and resolve all the outstanding issues among the parties. So MJ Dawson was not only doing work as far as the event center is concerned, but they were also doing convention center roofing work. And there were some issues involving the roof membrane on the top of the event center in terms, the convention center, my apologies, in terms of what they were doing. So with that concern, we got that golden seal warranty. So that is a lock solid, best in the industry warranty for any possible leakage or anything else with that roof. As far as the event center goes, you are having a resolution of the aesthetic issue regarding the less than smooth metal panel siding. But as Karen had indicated to you, there still is all those potential latent defects. And what I want to emphasize for the public, we're kind of glossing over what the word latent really means. What latent means legally here is it's undiscovered. Latent defect is something that we're not aware of. And certainly a latent defect could be a whole host of things. And the settlement agreement is very good list in terms of the types of issues that may arise should a latent defect appear. And what I think the citizens need to know is that with the statute of repose, you have 10 years, so until 2024, where there could be a latent defect arise. And certainly that is part of the protections that the wisdom of the state legislature set in place. It protects entities, it protects owners of public buildings, owners of private buildings, in terms of if there is a latent defect, something that's not discovered yet but comes or arises later, that's there. And on a contingency fee, the issue you need to remember is that Mortenson would have the ability to recapture all of that money without this release and use up to $1.5 million should even a latent defect have been discovered if we would have done nothing. And what happened was when they released and forever forfeited the $514,000 as part of in addition to their $160,000 cash payment, you're talking about almost $700,000 of value by Mortenson, because they are on the hook if there is a latent defect discovered for another 7 years. If something is discovered in a latent defect, that would require that amount of money. So there is new value there, and I think that kind of covers in terms of the types of things that were released. So I hope that answers your question.
It does, and I'm trying to, because there's a lot here in a short amount of time. We've got answers to questions that were delivered after 3 o'clock today, so we're trying to sort through that at the same time. So I've had a lot of constituents say to me that we got $1 million for a problem with the siding. But if I go back to what Director Cotter was saying, there isn't a problem with the siding. So I'm trying to figure out why we got $1 million if there isn't a problem with the siding.
Counselor, if I could, essentially after extensive review with industry professionals and throughout the design and even the installation and doing additional things on that west side that we did, which was double the girth of how those panels are attached. We put an additional strut at the end points of each panel to pin that corner. That's how we can say that they are structurally sound. Largely, we got to the point with our entire team that this is an aesthetic issue. And so in instead of spending $1 million on trying to fix an aesthetic issue, we asked the design and construction professionals to make a contribution that ultimately went into the settlement that we could spend on other fan enhancements for this building. So that's essentially what the settlement was. In lieu of trying to address an aesthetic issue, the design and construction professionals were asked to make a financial contribution. That's essentially what it was.
If I can, one more just that I want to throw out there. One of the things that I'm also curious about is the Judd Allen Group report. And I'm concerned when we say that we hired a consultant and they didn't finish or they didn't complete the report, the legal standard that would make it a public document. Couldn't we say that about all consulting reports in the future, that they're never completed? We have the choice. Statute doesn't require us to release those documents with the report from Judd Allen, but we could. We've made that choice to not release that. Was that covered by the settlement agreement that it can't be released, or is that a decision that we've made as a city?
Counselor, in the probably thousands of cases I've litigated over almost quarter century, I can tell you that you have what's called consulting experts on most cases, and certainly this is, again, a complex construction case. The Judd Allen Group was identified as a potential expert regarding metal panels in particular, and design standards, installation issues, and the sort. When you have a potential for litigation and you anticipate that it would occur, you try and consult with that expert and retain them, so that, frankly, it's part of a litigation strategy so the other side doesn't get to them first. Frankly, that's what you do. It's a race to the experts. And when you try and find national experts that can come in and do that type of work for you, that's the first thing when you take on a case, is you try and find those experts as fast as possible. And then you want to get them to the site and to do an initial viewing so that later on, if you intend to use them as a testifying expert, they would call, if litigation ensues and you're going to need their expert opinions, you want to have that initial site review done so they don't have to come back and do that again. Then you can start giving them more documents, provide them the rest, and have them give you a finalized report. As part of the consulting expert retention, you do ask them for their initial impressions. And again, don't want to say it's an uneducated guesses at that point, but they're hardly fully informed guesses at that point in terms of types of issues that could arise and where we would need to go. And a lot of it is identifying the types of documents that expert would need, strategies for the litigation in terms of how you would go forward. And in the thousands of clients I've had, my advice has been consistent every time. You do not reveal those consulting expert reports because it gives away all your trial strategy, where that expert would go in doing their opinions. And again, in terms of why we wouldn't even release it now, it's simple. The state statute says draft reports are not public documents. We're going to follow that because there are only impressions. They are not fully finalized impressions. He is certainly talking about all the, everybody involved in this litigation. You do not want to have out there opinions and impressions that are not fully informed yet on other people, private entities.
So we could release them?
I would not, no. I'm again recommending no.
That's a policy decision, isn't it, necessarily?
I'm recommending
it's legal counsel that you're providing your opinion to us, but that's a choice that we could make or needs to be, trying to differentiate between the two. The other thing is that in this situation, that's our expert that we're using as saying that it's structural or that it's not structural, that it's aesthetically pleasing or not. But that's one of the key things for us to make a decision, or a previous council to make that decision, the opinions that we received from this consultant that everything's okay. We take Director Cotter's word. We have done that internally, but that's the one outside place where we have a chance to say that everything's okay, that it's aesthetic.
I'll defer to Mark Cotter, our professional engineer, who's our Public Works Director.
I'm good with that for now. I think there's other counselors that want to jump in on this too, so I'm going to back up.
Before I go around to the next counselors that have indicated they'd like to ask more questions, I just want to make sure that, okay, Counselor Neitzer.
Let's continue with the Judd Allen. I think I heard what the city attorney said, paraphrasing, essentially was, if state law allows, for this administration's position would be, if state law allows you to hide a document, you're going to do that. Is that what I heard? I think that's what I heard. Mm-hmm. State law allows you not to release a document, therefore you're not going to release it.
I think we've already answered it, Counselor, but again, state law provides that protection for a good reason, because drafts are not final. And
taxpayers paid $5,000 for a report.
Mm-hmm. Most of it was site viewing and interviewing people, Counselor. That was the bulk of what that money was spent for.
Jim,
to get that expert on board.
Okay.
Now,
Exhibit 23. This is the invoice from Judd Allen. Let's put it up on the screen. I just want to take a look at it real quick. By the way, what is email on corroding edges? Does anybody know what that means? What corroding edges? It goes back a couple years. I'm just curious if anybody knows. You'll see what I'm talking about.
I think other way.
Way down. You go to 23. It's about page 20, 25 or so. Sorry, I had a lot of possible things I was going to talk about. There you go.
There it is.
So there's a statement about email on corroding edges. I was kind of curious. Does anybody know what that was? Okay. So edit and send preliminary report. So I'm curious, this particular report, was that an email? Was it a Word document attached to an email? Anybody?
Would anyone from the administration like to answer that question in regards to Counselor Neitzer with the preliminary report?
Counselor Neitzer, there was an email attachment.
Okay.
I think there was a question too about the corroded edges. I don't know if that one got answered either.
If nobody knows, that's fine. I guess I just go back to, we've been told, I think what this all comes down to is, for us as a council and to be able to tell citizens that your building that you paid $100 million for is okay, and to have some independent assurance from somebody to just say, yep, it's fine behind the panels, it's just aesthetic, and put that to bed. I don't understand why we wouldn't release this report or release something else, an independent verification. As much as I respect Director Cotter, independent verification. That's all we're asking for.
Councilor Staley.
Would Attorney Fifley please come to the podium again?
Jeez, it's not a trial.
I just want to ask a question. Have you heard any statements here today that you believe are not accurate?
I haven't been taking copious notes. My apologies, Counselor. I didn't.
That would have come from the administration.
From the administration, Counselor?
Yes.
No.
Okay, thank you. And then lastly, I'm going to say again, and we've been having this discussion about verification of what's really going on behind the panels, with the panels. I think that we, as a council, need to require an audit of this project by an independent auditor to determine what actually has taken place. I think the citizens deserve this. I think they would support this. And then we know for ourselves what really was going on, and we can move ahead with that solid information.
Councilor, I'm sorry. Were you finished?
Thank you. Yes, I'm done.
Sorry about that. My apologies. Councilor, do you have a question?
Yes, Madam Chair. Quick question. If another latent defect should arise, would there be another settlement? Would that be prorated for time past?
Should something occur in the next 10 years and there is a latent defect, the answer to that would be is we'd follow the contract terms. If the parties dispute it, And we get into dispute, and we need to go through a mediation process, and there's recommendations made by experts to us. It all depends, and so it just depends on what the issue is and what the nature of it is, and is it truly a hidden defect? And those are all in state law too, that carves out exceptions for whether or not it truly is latent. And so we would follow the law and follow the contract terms.
So it might be more negotiations to come if something like that would occur?
Sure, anytime you have a construction dispute, that's always possible.
Okay. Okay, thank you.
Mm-hmm.
Any other questions, Councilor? Otherwise, I'll ask a couple and then come back around. Councilor Rolfing.
This has been really interesting. It seems like we've answered all the questions, or the administration has. There's been a little bit of a witch hunt by certain media in the city of Sioux Falls on this one. They'll tell you that's what their job is, and to a certain extent they're right. However, the presentations that they've done, and some others, make it sound as though there was a money missing or stuffed away someplace that nobody's going to know. That simply is not the situation. It is not. My feeling is, after knowing all the things that I know, and that you know, is that this was a perfectly legitimate, perfectly legal settlement. And because the Supreme Court overturned it, now it's being turned out to everybody. Public trust was always first in mind. Nobody was trying to pull something over on somebody. Councilor Staley's rebuttal today was reminiscent of her newsletter, full of innuendos and misstatements. I would hope that negativity would cease, but I don't have much hope of that. I believe that also, to answer that question, Director Cotter told us, when most of you, I think it was just Councilor Beck and myself were here, that from that report, that Judd Allen report, that it said that there was no structural problem with what they had seen at that point. And so that's there. There's no problem there. And one other thing that I don't think the Argus leader or some other people thought about throughout this negotiation, or whatever you want to call it, is that it's going to cost all of us, all of you, more money to do any project from now on, because we don't have the confidentiality that we would like going in this kind of agreement going forward. Every contractor is going to build in 5, 10, 15, 20% more into their bids, just so they can cover the cost of litigation that may happen because we can't negotiate a settlement like this in the future. Their reputations are one of the things that they live for, and they're going to fight like tooth and nail to make sure that they're not the ones that have to pay the bill. Think about that in the long run, what just happened to the city of Sioux Falls and to the people in the state of South Dakota. So I want to thank the administration for bringing all these questions, answering all these questions, and being honest with us, and being forthright, letting the settlement agreement out in one day when they didn't have to do anything, and for 60 days, according to the settlement or the Supreme Court. And all they did was take some time to tell the people that were in the settlement agreement what was going on, so that they didn't get blindsided. One day, and they get, makes no sense, folks. Look at the math. Look at what we got. It's no different than if you didn't like the paneling that went on your new house, and it wasn't quite right, just not quite right, and the contractor said, well, I can take it off and replace it, or I can give you a credit, and you can live with it. That's what happened. Thank you.
Thank you. I have a couple questions. I find sitting here sometimes is hard because you have to wait, and you know most of your questions are being asked, but it also sparks questions as well from all of you. So with that said, I have a couple questions, either Karen or Fifely, whichever one wants to answer, in regards to the latent defects. This isn't obviously my expertise, it's yours, and so my question is if this is something that is included in every single contract, this latent defect, that is always in the construction manager at risk, is that something that's always there?
It is in the construction manager at risk contracts that the city has entered into because the statute of repose deals with construction of buildings. And so all of our contracts say we follow state law. And the paragraph on 13.7 that I referenced is, I know in the event center contract, but I'd have to go back and look at the other 3 contracts we've entered into to confirm that.
It's very common for us to have that.
Yes, it's very common.
Okay. So my question is I fall kind of along that same line as, well, let me ask it this way. Did we have to bring Mortensen into the lawsuit? Because if we didn't, we could have saved that $514,000 and not had to give back what was in the contingency. We could have just kept it. And so if we could have said, okay, Mortensen, you're off the hook. It's not going to be you, but we're going to go to the rest of the contractors and not hold everyone equally harmless. We're just going to go over here so we can save $514,000. Is that an option?
The short answer is no, because the contingency, the way it was set up is that Mortensen could use the contingency towards corrective work of their subs. And so that's how we got to that. We don't have contracts with the subcontractors. The city did not enter into contractors with MJ Dawson. Mortensen Construction did. It was their subcontractor, and in the contract that the city had with M.A. Mortensen, the construction manager contingency fee was allowed to be used for corrective work of their subcontractors.
And I think that's the tough pill for me to swallow, because it feels as if, I know I read a recent article, I don't know who said it, but that said, that's the taxpayers' money and we get it all back. And I went, ooh, okay, so now when you hear that we were supposed to get it but we didn't, I mean, it's just really confusing, I think, to most that don't deal with this for that reason. Because it sounds as if, you know, we have this contingency, we don't use it, and you don't understand what the latent defects mean, you would keep all that money. And so it is quite confusing for that and how that looks. My question also I have in regards to when we talked about the arena just a few weeks ago, we talked a lot about how it was value built. Was this siding that was used? We've seen some of the estimates as far as you can use siding A, B, or C. A is going to cost this, B is going to cost this, C is going to cost this, and C is the least amount of money, and that's what we went through. So would this be considered as value siding because we went with a lesser option than all of the other products?
I'm going to turn that over to Mark Cotter.
Okay.
Thank you for the question. I think, you know, one thing that owners across the country are really facing with the size and scale of these buildings are getting larger and larger. They have to find something that's attractive but also economical to put on the outside enclosure of these buildings. And so when we looked at a combination of metal panel, precast, and windows, that's really our exterior enclosure. Was it economical? I would say it's a very good system, and that's been confirmed not only by our design professionals, but then we went out to an outside enclosure team. It's one of the best in the country. I think it's item 36 in the questions that you've asked for, and that full enclosure study is in the document. And I would encourage you to read it because I think it will provide a much better review of the details and the installation methods to give us that assurance that we have a really good system. And then I think just in general, we as a design team said, we know that the spectator's experience is in the inside of the building. And so we want to make sure that we have an attractive and functional exterior, but we're going to really enhance the spectator experience inside. And that's why you see this building that performs so incredibly well.
Thank you. So a couple more questions that I have, if I can. As going back to the contingency, you know, we've had contingencies on pretty much every project that we've done. I know we had one on the Indoor Aquatic Center as well, and it's contingency. And I guess my mindset is that's always fan enhancements. We can do better seating. We can do additional fireplaces, maybe larger TVs. That's kind of the way, I guess, it's always been sold to us. And then to kind of learn today, like, oh, but wait, you have to wait until there's no issues with these contractors, first and foremost, before you can expend that money, I think is a little, you have to be a little more conservative. I mean, we have to hang on for 10 years to making sure that we still uphold the end of the deal. So I think that's a little interesting with that on how that works. My other question, though, that I want, well, sure, if you want. Yeah, sorry. I guess I didn't even let you answer. I didn't really have a question about it. I think it's just confusing.
If I could, Counselor, just to, when you ask a contractor to give you a guaranteed maximum price at some stage of the project, whether it's at the very beginning, a third of the way in, wherever that stage is, normally they have not bid out every schedule of work. So on this project, there was about 25 different schedules of work, from the footings and foundations right down to the painting schedule, right? And so they do their best they can when they're building that guaranteed maximum price to go to the market and get good ideas of what those costs are going to be prior to the final design of all those schedules. So what happens is then time passes, and so you may end up getting a very competitive bid. They may end up getting a very competitive bid on the foundations, but by the time they get to some of those other finished schedules, you know, if they have the painting at a certain amount and it comes in higher, ours did, there's so much work happening in our market, and so they can then utilize that contingency to still deliver the project. And so I would tell you, don't always look at contingency as just fan enhancements, because they are bearing a significant amount of risk to deliver the project. And we're all hoping that every schedule of work would come in competitively and all those contingencies dollars would be available for potential project alternates, but that's just not the case.
Right. Thank you. So then the last thing I want to bring up then is the Judd Allen. I was on the council then with Rolfing and Erpenbach, and I do not remember hearing that there was no problem with, I know you made a statement with that, and I'm not quite certain I'm following that. But I think that what I'm hearing others share and what I'm hearing in the community is show us something other than Director Cotter, who I respect greatly. Show us something that says that there is nothing wrong with the inside of the paneling, everything is all good. And if we spent $5 grand on that through Judd Allen and you can release a report, do it. Why not? What's the risk in doing that? I guess just because you don't have to doesn't mean you shouldn't. And that's what's a little bit frustrating on my end for that is I respect that we use outside consulting agencies all the time. Oftentimes we criticize you for doing it as well, because we say, how much money are you spending on a consultant? How much money are you, I mean, we criticize you all the time about that. This is a time where we're asking you to do it. We're asking to say, peel back a little bit, hire someone, figure it out, let's talk about what that looks like, just for the sake of the public's, I think, comfort level, and the public going, okay, you know what, sure, it's bumpy, I think it's ugly, somebody might think it's pretty, I don't mind it, but why not do it?
And Council Vice Chair Erickson, with all due respect, and I mean it sincerely, these are the same comments, the same questions, the same inquiries that we had 3 years ago. It's the same thing. And that, again, is why, you know, again, I respect the new council members who weren't part of that. I understand that. At some point in time, you move forward. Again, and I don't want to minimize this by always talking about, you know, our homes or our small businesses or our churches but we all, not all, but most of us will go through something like this. And at some point in time, you make a decision to move forward based on what you know at that time. And that's exactly what we did 3 years ago. That's exactly what we did 2 years ago when we negotiated this confidential settlement. And what I can express to you is that The place has been open now for 3 years. It is performing beyond our expectations, inside and, yes, out. And so again, I respect the questions. I get it. But we have answered all the questions that have been presented. And in fact, we've answered them to the media too. Now, again, the reality, and it is the hardest part of being in government, is the reality is that no matter what answers we give, no matter how much detail we give, no matter how much we peel back the onion, there are still some folks out there who are not going to believe it, or they're not going to like the answer that we gave. And so I guess at some point in time, I would just ask, again, we did this based on trying to represent the people of Sioux Falls very well. And yes, as the administrative branch of government, we actually have this role that we have to execute. And it's not to minimize the legislative branch. It's not to exclude you. It is, though, to try to move forward and then go capture other opportunities or address other issues within Sioux Falls city government. But certainly, we respect the questions, we do, and we'll answer them the best we can. And even today, you saw that there's going to be times where we'll respectfully disagree. But again, Council, thank you. And Councilor Erickson, I think that we can provide you some additional assurance to make you feel more confident, as well as the rest of the people of Sioux Falls, that yes, not only is it structurally sound, and yes, in the eye of a beholder, I believe it's aesthetically pleasing, but I think that we can do that for you.
Thank you, and that
You're
was
welcome.
my follow-up would be is what assurance can you, with your
Yes.
good reputation,
Yes.
give the taxpayer that
I
the
got it.
siding is adequately protecting the event center?
Thank you.
I think that's,
No,
at the end of the day,
yeah.
the big thing that will help people move on.
I think that's fair.
Any other questions from the council? All right, I see none at this time. I'm sorry, Councilor Starr.
I think one of the things that we need to do as a council is what's our next step? I don't think I'm done with trying to understand exactly what's going on here as part of this. I think one of the things that we need to do is schedule another informational when we get a chance to digest the answers to the questions that we got today. So I would suggest that leadership work with the administration and we do a follow-up session on October 19th at our 4 o'clock informational.
Thank you for the suggestion, Councilor. I do understand your desire, as you know, we did submit questions that were not on the paperwork, as well as sending through about 40-some questions through to the administration, as well as asking for different exhibits, and many of us did the same research outside of that. And so much of this we have only been able to digest 30 to 40 minutes, no fault of the administration, it's just the timeline that we're under. And so I will also discuss it with Councilor Kiley, and we can talk amongst ourselves to see next steps and see if that's something that we can certainly do as we kind of digest the questions and kind of move forward from there. And I believe that there was a handful of additional media questions that we're still looking for answers as well. And so I just encourage them to resubmit if you did not hear your question being asked today. Make sure you resubmit those, and we can have the Attorney's Office follow up from there as well. Councilor Staley, did you have one more thing?
Well, I was just going to echo, I support what Councilor Starr said. I think that it's going to be fair due diligence to the citizens to digest this information and then to readdress this.
Thank you. Councilor Urbanbach?
Thank you, Madam Chair. I just a couple of things. I don't disagree with the next conversational session. I wonder if it might be a work session. I would ask leadership to consider that. The other thing that I would think about is we very often, and I hope all of these questions, because we have been just inundated with not only the questions from ourselves, but from the media, and then the answers and I apologize, the lawyers speak. You know, it's way up here for some of us, right? I would like us to, and I realize most of it's on SIRE, but I wonder if we wouldn't consider a basic Q&A page about the settlement, so that every one of these questions that's been asked by the media, every one of the questions that was asked by the council is then worded exactly the way it was asked and answered in the way it was answered, so that it becomes a web page that we can refer back to. But I do think we're at a point where I don't know that that we're at a confusion level. I think we're at a level where we have some very sincere questions about terms like contract manager at risk, construction manager at risk. What does that really mean now? What are the things that are truly underlying this conversation? And I see some of the candidates in the audience today, and I know that some others, council candidates, are watching now. I would advise you to read everything, read every detail, and ask every single question. Because at this point, I'm feeling just a little bit like I ask a lot of questions and I didn't ask enough. I didn't ask enough questions. So it's on not only the administration, but it's also on the council, that if we feel like we didn't know enough, if we feel like we've been hoodwinked, then shame on us, because we didn't ask enough questions. But I would encourage us to have more conversation, and I would hope that the administration would put a web page up with a basic Q&A with the wording as it is.
I think that's a good idea. I think that would be helpful as we, doesn't matter where we go, we're asked similar questions over and over, and to be able to refer them to the exact factual way in which legal terms, I think that's a good idea. I think that would be super helpful for a lot of folks. All right, seeing no other questions, we will adjourn this informational 7 o'clock council meeting back here. Thank you.